All right, guys, thanks for that. And we will talk to you to close us out at the end of our hour. We're going to bring in our next guest. We've got Anne Reinke joining us, president of the Transportation Intermediaries Association. And Anne, thank you for being here. We got two topics to toss up to you today. The new FMCSA ruling on preventing broker fraud. We've also got now another new ruling coming down in broker carrier liability. I'll give you dealer's choice. Which one do you want to talk about first?
Gosh, let's talk about liability first.
All right, let's do that. So we've seen a couple court cases come down. Things have, of course, gone in differing directions from different district and circuit courts. We have now another ruling coming out of Oregon talking about this one found the broker not liable in a case that also involved double brokering. What does this mean, broader perspective for the industry? We heard from John Kingston on it earlier this week, and he said it's going to have to go to the Supreme Court.
I think he's exactly right. This is the proverbial split in the circuits now. When the C.H. Robinson case was first sent up to the Supreme Court, there really wasn't one. And in that time, since it was rebuffed, so to speak, we've had these cases, one in the 7th Circuit, one in the 11th Circuit, and now this was a district court case, as you mentioned, but ultimately to the 3rd Circuit. So while this case came out, as you know, the Ying Yi case, they went to try to petition cert again to the Supreme Court. I think that, in my view, and I'll agree with John Kingston, this will get taken up by the Supreme Court this time because there is this split.
As you look at it in terms of how this plays out with broker liability as a whole, obviously the major argument is F4A. That's the thing that's going to stop this from getting two brokers. And it seems like in these cases that have differing opinions, we're almost down to splitting hairs. Is it really that pointed a discussion that we're just talking about a word here or there is going to make a decision go one way or the other?
Gosh, I don't think so. To me, it seems sort of like a philosophical bent where the 9th Circuit seemed to think that the safety exemption existed here to F4A, and the 7th and the 11th Circuit, and now this district court says, no, there is no safety nexus. I mean, the case that just came out, this Gulf Transportation / Coyote Logistics, seems even more attenuated from safety, right? Because of the double brokering that occurred in and amongst between. But ultimately, these decisions from the 7th and the 11th were full-throated endorsements that there is no safety nexus between the broker doing its job in selecting a carrier and then ultimately what happens on the road when the driver performs that action. So to me, that is pretty strong language. Obviously, the 9th Circuit to me seems a little bit of an outlier in that respect.
So, and we also asked John Kingston about the effect that this is going to have on insurance in the meantime before we get a ruling, because, of course, this will take a little bit. The Supreme Court has to pick it up if they decide to. And then, of course, they have the ability to say, you know what, just kidding, we actually don't want to hear this case or not. In the meantime, for brokers who are trying to protect themselves against this, protect themselves against the nuclear verdicts that come down when we see accidents like this happen, and from that liability that gets thrown back on them, what does this do for their insurance rates? And even for carriers as well, does it now increase rates and add just another level of complexity to this broker-carrier relationship?
I don't know if it changes the rates so much as it the sort of lack of clarity persists, meaning that there's still a potential for nuclear verdicts. There's still a potential for brokers to get hauled into cases. There's still a potential for carriers to get hauled into cases. That has not changed. Now, will they get will the plaintiffs bar who brings these cases against the brokers and the carriers be successful? Maybe not. But I don't think that has changed. One other aspect of this whole thing, which we haven't talked about, is that the FMCSA is doing their rulemaking on the safety fitness determination. Now, obviously, rulemakings take forever. I couldn't even predict when it could happen, but that is going to bring clarity to how you actually rate a carrier in terms of its safety profile, which ultimately is going to benefit everybody. And having FMCSA take, the responsibility of using data to make the safety, rating will be enormously helpful for it and for us, our members.
Well, I have the dubious honor of going to the other topic, the one you didn't pick. So let's talk a little bit here about the FMCSA's new ruling on basically kind of regulating the financial aspect of brokers here. 5 subjects they came out and decided to make more stringent regulations on. I know TIA is proposed been for this, but what stood out to you in terms of this rule?
Yeah, I think a couple things. One of them is that the FMCSA now has accepted that it has responsibility over these trusts, the BMC 85s, which initially they were confused that they thought it might be state regulation. They didn't think they occupied that field. So now that there's clarity on that. The FMCSA has regulatory authority given to it by Congress to regulate these sureties. The other piece of that I think that stands out is that these sureties have only a certain number of acceptable assets that they can declare to say that they are collateralized, right? So instead of saying someone's inheritance or someone's donut shop that they're going to, get a share of or whatever else, it's the irrevocable letter of credit, it's cash, it's bonds. So having that sort of narrow prescription of what actually is eligible as full-on assets, I think is helpful to us, to our members, so that it's not these fly-by-night operations. I don't like to besmirch anybody, but you don't want them to be sort of like an operation where they go into business and they're a payday loan kind of thing, and then they go out of business. You want these people to have assets so that they can pay claims and that there is clarity around that.
So, Anne, with this, obviously, it's being enacted to prevent some of that nefarious activity and ultimately to protect your carriers from not being paid when you see these operations end up going out of business or get to a point where they don't have the ability to pay the people that they're owed. But does this now present a pretty big barrier to entry for maybe people who are looking to get into the space for the first time? As we mentioned, hearing about this from our top story this morning, people have about 7 days of compliance to get into compliance with some of these now rulemakings. And what does that mean for smaller entrants looking to enter the brokerage space for the first time? Are they going to have to work a little bit harder to get that operating authority?
Well, the bond limit hasn't changed. I mean, it's still $75,000. They didn't increase it. If you recall way back when in 2012, I think we were petitioning for a $100,000 bond limit, and that has not changed. It's still $75K. Now, what I guess could change is if there are claims that go against that $75,000 and the broker only has $75,000, I guess that's probably an issue. But quite frankly, if you just have a $75,000 bond, but you don't have any more assets beyond that, that's a problem. You shouldn't be necessarily in the business if that's the only kind of asset you have is this bond. You really need to make sure that you have assets to stand behind it. I do think that they made a good suggestion in providing due process, providing adequate notification, providing 7 days, notice, and then having 30 days essentially to rectify, ultimately to 60 days. So look, I think there's plenty of opportunities for a broker who could be small to make sure that they can pay what they need to pay. But I do think it's a responsibility that you make sure that you have you pay the carriers that you do business with. And so these brokers, everybody needs to make sure that they have the assets to pay the claims that are against them. If they're fair.
Okay.
Of course.
Of course. We've got about 30 seconds left here. In terms of the final rule, as you see it, did it go far enough? Did it go too far? Did it not go far enough?
I think ultimately we have no complaints. I think, could there have been some other things to push? Perhaps. But ultimately, a lot of the comments that we had, it seems like they listened to, they incorporated some suggestions. And as you know, we and OIDA worked very diligently on various iterations throughout this process. So I think ultimately we're pretty pleased.
All right. It's great to hear from you on this and many more things in the future. Anne, thanks so much for joining us.
Thank you, guys. I appreciate it.
All right, let's head back over to the wall for our next check of weather with Kaylee.